Doncs, benvinguts a la segona part, bienvenidos. Continuamos con este seminario. Es una pena que no hagamos más de estos, porque la verdad es que es súper interesante y deberíamos intentar disciplinarnos para mantener esta llama viva. Bueno, pues ahora viene la parte del panel senior. No sé por qué motivo Tony me ha pedido que la modere yo. Bueno, pues sin demasiados preámbulos, va a ser un panel con 3 intervenciones. La idea es que las intervenciones sean entre 15 y 20 minutos, no más, para dar un margen al público presente en la sala para que intervenga. Y sin más preámbulos, le paso la palabra a Ricardo Luporini, que hará la primera intervención del panel. Ricardo?
Yes, thanks. Thank you very much. First of all, I would like to thank Susanna, Professor Susanna Borres, who is not here, but she facilitated my participation in this seminar. And then, of course, the director, Pigrau, and all the other, all the people who work for the organization of the seminar. For me, it's a great pleasure to be here. I'm very sorry I will speak in English. I speak some Spanish, but then I thought that for the presentation itself, would have been better for me to speak with English. If you have then questions and comments, and if you like, if you prefer to ask in Spanish, I would be very glad to answer in Spanish. Try to answer at least in Spanish as well. I just still 30 seconds or 1 minute to my presentation, just to integrate a bit my self-introduction, as I will be here only for today, basically. So it's a very short visit. I am a postdoctoral research fellow in international law at the Scuola Superiore Sant'Anna in Pisa, and I mainly work in the field of international disaster law, that is this emerging branch of international law, which is under a certain spotlight at the moment, as well as international climate change law and the interactions between these bodies of law with the protection of human rights. And on these issues, I also wrote this book, and I published this book last year, my research monograph last year with Springer. And if you're curious, then the book is here. And however, my presentation today will not be about this. Of course, it builds on my work over recent years. But it's more specifically about an article that I'm writing and drafting at the moment. Okay, so it's a very work in progress, and it's an article that I'm drafting for a special issue of the Italian Yearbook of International Law that will be devoted to strategic litigation in international law, to be published at the end of this year. Therefore, my article and my presentation, with the idea behind my research for this article on this special issue, was to focus on, let's say, try to understand whether, how, and to what extent this explosion, if you want, and consolidation of strategic litigation on climate change, and in particular human rights-based litigation on climate change, might be transferred to the field of biodiversity. So if this tool might also be used to counter the global biodiversity loss that we have at this point. Okay. So this is the outline of the presentation. I will start by looking at the main features of strategic plan litigation. Again, strategic here is emphasized also in light of the focus of the special issue that is on this specific term, so to say. And then I will look at the prospects for the development of this strategic biodiversity litigation. And here, the focus will be in particular, because this emerged as, let's say, a suggestion by the editors of the yearbook and other scholars during the first workshop that we had in November in Trento. It emerged this suggestion to have a more specific focus and try to see whether, how, to what extent the ruling, the quite landmark ruling and also controversial ruling that we had by the European Court of Human Rights in was April 2024, if I'm not wrong, on this Clima Signorinen case. The arguments, I mean, the findings of the court in that case might be applicable to hypothetical complaints in the field of biodiversity. So this then, I mean, I will come to this specific focus in a few minutes. So let's start by looking at the defining features of the model strategic climate case. Of course, climate change litigation is a very broad field. Also, strategic climate litigation is a broad field. However, we might try to define what are the main features of the model case in this regard. That means I would say this one, okay? So a case brought by individuals and associations that challenge the state's systemic mitigation regulatory framework, so-called government framework cases, okay, that address what, so to say, what the state, a single state is doing in climate change mitigation, so in emissions reduction. And this case is built on a global mitigation objective that we find in international climate change law, starting from the UNFCCC and in particular the Paris Agreement, and this state's national fair share, so a national contribution at state level in meeting this global mitigation objective. And again, most of these cases, or the model case of strategic climate change mitigation, we can say that is based on human rights, okay? So on this link between an insufficient climate change mitigation action and a violation of positive obligation to protect human rights. Again, there are many examples, starting from Uganda that you might know in Europe, many other cases, and also rulings in the Global South. Perhaps the Clima Signorinen, all the development of the case, and then in the end, the ruling of the European Court of Human Rights in 2024 might be considered somehow a model in this strategic human rights-based climate change litigation. I don't, and I mean, I give it a bit for granted that you more or less know what the case was about, okay? So a case brought by individual senior women from Switzerland, as well as an association, and in the end on challenging, well, actually now I'm going to the case, but very briefly, like challenging the mitigation policy of Switzerland in particular. And in this case, in the end, the court ruled in favor. I mean, it found a violation, in particular, of Article 8 of the European Convention of Human Rights, based on the critical lacunae that the court found in the Swiss mitigation policy. Okay, to put it very briefly. But let's go to biodiversity. Okay, so here the point is that if we have a climate crisis or climate emergency, well, we also have a global crisis in terms of biodiversity loss. So we have plenty of scientific evidence, reports, and so on that provide an evidence on that. Of course, then we have some scientific uncertainties in more detailed aspects, as we also have it with regard to climate change. But we know that the cause is related to human activities, and then the impact of this crisis is significant. Okay? And so we might argue that the main objective that we have in the international biodiversity law, in the regime that regulate the conservation of biological diversity, well, that the international community is failing to meet this objective, and the 30-year and more long-standing obligations that we have in this regime. CBD, the convention was adopted in 1992 as a sister convention of the UNF treaties. And so from this, let's say, consideration, recently we had at the scholar level, at the scholarship level, this attempt to build, so to say, strategic biodiversity mitigation as a tool to address this failure in international or global action. And we have some references of recent works in the field, a review on biodiversity mitigation that show that actually also this field is a quite developed field, but very fragmented, so not yet elaborating this systemic and strategic approach. Then some of the first, here I mentioned some of the first studies on rights-based biodiversity mitigation or systemic biodiversity mitigation. What emerged is this intention, this idea to, let's say, develop rights-based systemic cases or strategic cases, drawing inspiration on climate change mitigation. So what happened on the development, so to say, that we had in the field of climate change mitigation. And it's not only how to say, an academic speculation, because we also have first attempts, also in Europe, for instance, this complaint brought by Bund, by Friends of the Earth Germany, before the German Federal Constitutional Court. We don't have the ruling yet, just the complaint. So on building on this, on these studies and on this case also examples, cases that we have in the practice, the idea would be to outline a clima signorinem type case related to biodiversity, and understand how the court might assess such hypothetical complaint step by step. So drawing inspiration, of course, from the clima signorinem ruling. So look at the factual elements, applicable law, some preliminary consideration, and then admissibility, merits, and remedies. This is very, now I enter into, I have 5 minutes more, so I enter into what I'm studying and trying to write on the topic, but again, this is a very work in progress. It's a very work in progress, okay? So in terms of the factual elements, what is important to stress, of course, is the human rights dimension of the biodiversity crisis. And this can be done through the concept of ecosystem services. So all what we get for free from nature in terms of material needs, food, if you think of pollination, health, and also cultural and well-being dimension. And then I would also like to outline hypothetical circumstances of the case, okay? Now I'm trying to do this, but we might think at different examples. Complaints, situations that both include individual applicants and association, local forest guides that challenge the degradation of a given ecosystem, so the insufficient action by public authorities in protecting such ecosystem, small-scale traditional fishers, or for instance, what to say in English, beekeepers, right? So apicultores, an association of that kind. So many different ideas of complaint, but then the point to make is that such specific circumstances of the case may also not be particularly relevant to the case success. This is what the clima signorinem in the end teach us. I mean, to put it short, of course, all the situation of the heat waves, impact on the senior women in Switzerland, in the end, for the ruling itself, was not so fundamental. Okay, and when it was, let's say, assessed in that, in the end, was denied. So this is, I think, a point to consider. Then, in terms of the preliminary consideration for the post assessment, of course, we have many different issues, but now here the point that I would like to stress is this one. So, if we could consider, and if the court could consider the biodiversity crisis as a global crisis, and therefore then stressing this need for a tailored approach to these cases, as it did with climate change. So this tailored approach to climate change and to climate change mitigation that distinguished climate change from a more, let's say, normal environmental litigation focused on localized source of harm was at the basis of all the ruling of the Clima Signorin ruling. Okay, is this approach, or is this need for a tailored approach applicable to the biodiversity crisis as well? I don't know. This is another question. And then in terms of admissibility, this tailored approach would then be, the application of this tailored approach to the biodiversity crisis and biodiversity-related complaint would then be fundamental for the court to go into the admissibility requirements, and in particular on the victim status of individuals, as well as on the standing of association. What we had in Clima Signorin and in terms of the victim status of individuals was that, as you might remember, we had this stricter, the identification of this stricter victim requirement. Because if not, differently, all the people would have been, all the individuals would have been able to bring the case because everyone is somehow a victim of the impact of climate change. Is this specific stricter test elaborated by the court applicable also to hypothetical biodiversity complaint? This is another point. And then, perhaps even more importantly, we had this opening, if you might recall, by the court on the standing of associations, even in the absence of individual victims. This was perhaps the most controversial part of the ruling. Is this type of opening of how to say finding applicable also in hypothetical case of biodiversity? If so, or better, if not, how the court could justify that? If so, how could the court maintain that environmental damage as such does not amount to a violation of the right protected by the convention? That is something that was stressed even in the Clima Signorin ruling. This is another point. Then on the merits, I'm still, it's even more, how to say, embryonic or initial, initial phase, my reflections, but 2 points might be the identification of harmful activities, because in climate change you have a clear source of the harm, that is greenhouse gas emissions. That comes from different human activities, but then it's something specific. While biodiversity loss is linked to different things. Okay, so land use change, overexploitation of resources, climate change itself. So this might also be a, let's say, a consideration of a point of stress in how the court would assess such cases. And then also, how could the court assess insufficient state action in climate change mitigation cases? In climate change mitigation cases, we have a benchmark, right, at the global level, and then in the end we have this emissions reduction target to use as a quantifiable target that are very important for the assessment of the court. What can we use in the field of biodiversity? We might use this Montreal global biodiversity framework and the targets that we have there, perhaps, but this is a soft law instrument, and so even here it's more complex. To conclude, and sorry if I take some more minutes. I don't conclude on the on this Clima Signorin model as such, because I don't have the conclusion yet, but I would come back very briefly to the more general context. So we saw that strategic climate change litigation emerged as a standalone field of practice and inquiry. There is this strong focus on right-based, olive-based cases that are impactful, but also they also have some limitations that cannot be considered as the panacea, the solution, of course, to the climate change problems, even in legal terms. What about strategic biodiversity mitigation? Now the attention goes, and I'm also following that direction, to the drone inspiration, following the climate mitigation model. But of course, we have to acknowledge the complexity of natural and legal biodiversity systems, and also acknowledge that there might be cases that look at less sexy, so to say, or lower profile issues, but that can be also impactful and strategic. So thank you very much for your attention, and sorry if I spoke some.
Para Gabriel, that is not like quite connected with the presentation, but I have only interest knowing your opinion about the recent decision of Macron to decide that carbon dioxide is not danger anymore, and how that affects to the state regulations.
Thank you, Digno. So this was the endangerment finding decision that I just mentioned, and I think you use the term. It's a holy grail. It's a type of holy grail action on Donald Trump's part, because in the United States, the endangerment finding is necessary. All it says is that carbon dioxide emissions from cars endanger public health and welfare because they contribute to climate change. And in 2007, our Supreme Court actually weighed in on this question. This was a big deal, the biggest climate decision by our Supreme Court. And it said by a 5-4 decision now, so very close, yes, you must regulate greenhouse gases using our old law, the Clean Air Act, if you find endangerment, and you cannot avoid finding endangerment if the science tells you so. The problem, in the first Trump administration, industry said, don't be stupid. Don't try to undo the endangerment finding because we think there's a good chance you will lose at court because the science is so clear. Now, in this second term, they're going for the Holy Grail. They're trying to, and they're hoping that they can get, because it was such a close decision before, and because this Supreme Court now has 6 conservative justices, because this Supreme Court has shown that, contrary to our jurisprudence, it is willing to overturn prior decisions like our abortion Roe v. Wade decision, that they can win on this and win at the Supreme Court and forever stop greenhouse gases from being regulated. I think who knows what will happen under the law. They should not win on that. But with this Supreme Court, they might. What is for sure is that now, for the next president, Democratic president, to regulate greenhouse gases will take a lot more time. That being said, we have not had a functional greenhouse gas regulatory policy at the federal level ever, except for cars. And what we have done is reduced emissions with tax credits and state policy. Both of those options are still on the table.
Gracias. Bueno, gracias a los tres por vuestras presentaciones, porque la verdad es que ha sido mucha información de mucha calidad y realmente, y si no es tu tema, la verdad es que estás aquí más aprendiendo que realmente pudiendo, según cómo hacer alguna observación. Por ejemplo, tu tema, Gabe, a mí es muy nuevo para mí. Creo que luego igual entre calçot y calçot iré tal. Pero entonces haré una pregunta, que no es casi una pregunta, pero yo he escuchado con mucho interés la presentación de Ricardo, porque además de los temas de biodiversidad, pues yo los trabajo también desde otra óptica, pero me interesa mucho. Y luego, al escuchar a Digno, que además conozco su trabajo y su discurso, yo pensaba, ¿cómo se hablan los dos? O sea, las dos presentaciones, porque yo creo que toda la temática de la litigación estratégica que tiene que ver con biodiversidad no deja de tener, y tú así también lo has dicho, un enfoque muy antropocéntrico todavía, ¿no? Y entonces el discurso de Digno da muchas herramientas para nuevos enfoques, incluso para estas estrategias. Y entonces, más que igual es una pregunta trampa, ¿no? Pero ¿qué os diríais vosotros dos con relación a lo que habéis planteado?
Can I answer in English? Well, I understood the question, of course, but can I answer in English? That is a central, well, maybe not a central, but a point that I consider. So the fact, I mean, the role that rights of nature might have in such, you know, hypothetical complaints and so on. My idea is that I mean, I didn't want. I don't know if I will include it in this specific study, in this specific article, just because not to put too much things in it. But other courts, and in particular the Inter-American Court of Human Rights, for instance, has been trying at least to be a bit more progressive in these terms. So it might be possible that the European Court of Human Rights, even if does not recognize, and then we will see how important it is to recognize natural elements as legal person. But even if does not do that, it takes these progressive statements or the advisory opinion, for instance, that has been also recalled in the morning, but the Inter-American Court of Human Rights as elements useful for interpreting the convention and the rights protected under the convention. So it's for sure fundamental. I mean, I see the intersection. It's a very fundamental issue, and yeah, and that's it. I mean, then I had before a more, let's say, limited vision actually of the rights of nature movement, but today I also enjoyed quite a lot to understand all the differences that there are behind that, and so also I would like to take this into consideration, perhaps. Thanks. Gracias.
Muchas gracias por la pregunta, y me parece que es muy interesante, teniendo en cuenta justamente el reciente desarrollo de la Corte Interamericana en la opinión consultiva 3225, Emergencia Climática y Derechos Humanos, a la que hizo referencia parecida en la mañana. Entre otras cosas porque varios de los problemas o desafíos que mencionaba Ricardo fueron abordados por la Corte Interamericana en esta opinión consultiva a partir de reconocer a la naturaleza como sujeto de derechos. Por ejemplo, uno de esos desafíos es los desafíos de la legitimación activa. Uno de los grandes problemas al momento dentro del campo del litigio climático es decidir quién tiene la capacidad de ir a una corte y decir yo hablo en nombre del clima global. Quién tiene la legitimación activa, el standing para representar al clima global. Y lo que se ha venido estableciendo en algunos casos, salvo el caso clima señorina, es debes demostrar algún interés directo en el tema. Debes demostrar de que te afecta de alguna forma o que tienes algún interés directo en el tema para poder activar en nombre de la naturaleza. Claro, esto genera muchos problemas en el litigio climático, porque es muy difícil demostrar que un proceso de contaminación específico de un país afecta a un grupo de seres humanos específico. Dado que el problema del cambio climático es un problema acumulativo a nivel global, separar los procesos de contaminación y atribuir efectos específicos de ese proceso a determinados grupos humanos es muy complicado. Dentro del litigio climático esto se llama ciencia de la atribución. Entonces, ¿qué hizo la Corte Interamericana para mí de manera brillante? Y aquí sí se ve, creo yo, en términos procesales, los beneficios del discurso de los derechos de la naturaleza. Dice, bueno, la víctima ahora es la naturaleza. Y en este caso, dice más la Corte, la víctima es el sistema climático global, que es un sujeto de derechos, dice la Corte Interamericana. O sea, hacer la víctima ya el clima o la naturaleza, yo ya no tengo que probar la relación entre una contaminación y la afectación a un grupo de personas humanas. me basta comprobar la afectación a la naturaleza, al sistema climático global. Y eso está perfectamente probado. Y está perfectamente probado como el aumento de las emisiones de dióxido de carbono o el no mitigar las emisiones de dióxido de carbono aumenta el problema del cambio climático, como sabemos todos y todas. Entonces, al ser la naturaleza víctima en sí mismo, esos problemas de standing, de acceso a el litigio climático, se resuelven. Otro de los temas que aborda la Corte Interamericana es el tema relativo a la prueba, que es en relación también con la ciencia de la atribución muy difícil. Probar que, una vez más, esta afectación específica genera este daño específico a este grupo de personas humanas. Esa prueba ya no es necesaria si solo tengo que demostrar que la naturaleza está siendo afectada. Entonces, flexibiliza mucho más el litigio climático, que creo es, en este caso, y dada la urgencia de lo que estamos viviendo, más aún con Trump gobernando el mundo, flexibiliza mucho más las posibilidades de que la sociedad civil active en nombre de la naturaleza. Entonces, quizás allí hay un beneficio concreto que pueda dialogar con esos desafíos que tiene el litigio climático en Europa. ¿Y eso dependerá de qué? Dependerá del movimiento social, básicamente. Los derechos de la naturaleza llegan por movimientos sociales.
May I add very quick on this, because this is very interesting, but then what happened in the Clima Signorinen ruling, for instance, that was considered a very progressive ruling on many different issues, is that the European Court of Human Rights said the opposite.
Yeah.
It said again, stating, of course, I mean, based on its jurisprudence, that environmental damage as such cannot be considered a violation of the rights of the convention. Okay, so it's in this specific aspect, it remain on the more conservative vision and on its jurisprudence. This is also why, I mean, would be difficult, at least in the jurisprudence of the European Court of Human Rights, to see this progress that I share, of course, would simplify a lot the problem of the victim status that at the moment was indeed the most controversial issue of the entire ruling.
Doncs, muchas gracias. Debemos cerrar porque el moderador tiene clase ahora. Entonces, continúen ustedes la conversación entre calçot i calçot, que seguro que serà productiva. Moltes gràcies a tots els ponents i també als que heu intervingut fent preguntes. Tant de bo ho repetim aviat i més sovint, perquè ha estat un matí molt productiu i interessant, i a gaudir de la calçotada.